네, 그러면 다음으로 UC 헤이스팅스 로스쿨 교수이신 비나 듀발 교수님께서 지금 저희가 얘기했던 여러
Can you hear me?
Yes, I can hear you. Can you hear us?
Okay. Yes, I can hear you. Perfect. So, hi, I'm Professor Dubal, and I'm honored to be before you today. I'm sorry I couldn't be there in person. I'm speaking to you from Silicon Valley, the heart of all the disruption. I want to give you a little bit of background on me and my research before I talk to you about AB5, which is what Professor Park wanted me to speak on. I am a law professor and I have a PhD from UC Berkeley. I'm trained as an anthropologist. So my research 10 years ago, more than 10 years ago, began in the taxi industry in San Francisco. I did an ethnography of the industry, many-year ethnography. And after I filed my dissertation, my research was disrupted by Uber and Lyft. Since then, I have done on my Uber project, I've done interviews with hundreds of Uber drivers in San Francisco. I've done a 250-person survey of Uber drivers in San Francisco. I've done in-depth interviews with politicians, plaintiffs' attorneys, defense attorneys, regulators, and I've also done a three-year ethnography of driver groups, both Uber and Lyft drivers in San Francisco. So I can tell you a lot about both taxi drivers and Uber drivers and the transition between the two. To give you a little bit of background on the folks in San Francisco who work as Uber and Lyft drivers, the majority of them actually are not using their cars in some sharing capacity. Many of them have bought or leased their cars through Uber or through third-party entities facilitated by Uber. Most Uber drivers who are working in San Francisco are either immigrants or people of color. The majority work part-time, but the vast majority of Uber's revenue actually is produced by full-time drivers. And I want to help make a distinguish for you part-time drivers in the Bay Area, in this very expensive area, are not driving to make extra money, just to have some extra money in the bank. Almost everyone who I've spoken to is actually using this to make ends meet, to put food on the table. So they are highly dependent, despite the fact that they are part-time drivers. So that's just sort of a background on the workers in the industry. Should also say that by Uber and Lyft's own accounting, only about 4% of drivers who began driving continue to drive after their first year. And a large percentage of the 4% of folks who continue to drive because they are carved out of other forms of wage work, or because they have either bought a car or have bought a car through Uber, through one of their predatory loan processes that they've recently been fined for by the federal government, and they have to keep driving in order to pay off the loan that they have taken on. So it's a very sort of precarious situation for Uber and Lyft drivers in this San Francisco Bay Area economy. So that's just the backdrop. You might know this, but in the US, economic security comes almost entirely through work. So unlike in Korea, we don't have universal health care. We have very stringent forms of welfare. And even under our welfare programs, recipients must be working or looking for work. So not only does economic security come through work, but in order for that work to be secure, it actually has to come through employment specifically. So since roughly the late 1940s, for the purposes of social benefits, we have two types of workers in the US. We have employees who get wage guarantees, who get workers' compensation if they're injured on the job, who get unemployment insurance if they're terminated through no fault of their own, and most centrally, who have the protected right to organize and join unions. Then we have independent contractors who don't have any of those things, who don't have wage guarantees, who, if they organize to form a union, risk violating antitrust laws, who don't get workers' compensation if they're injured, etc. So it is the case that in the US, a taxi or Uber driver could work 16 hours a day and go home with less money than he started with. And this is legal if the driver is truly considered an independent contractor. Because we put so much pressure on employment in the US, having an employee costs a business 1/3 more than a business that has an independent contractor. So businesses are therefore incentivized to classify or misclassify their workers as independent contractors. And since roughly the 1970s, businesses have sought to change or challenge the definition of who is an employee in order to make it more easy to classify workers as independent contractors. I'm going to get a little bit into the weeds of the law here, but it's important to understand the significance of AB5, the test in California, the new law in California. But the traditional test to determine employment status is some version of how much control the putative employer exerts over the means and manner of the putative employee's work. So the more control an employer has, the more likely that the worker that he has will be considered an employee and not an independent contractor. And notably, it doesn't matter what the business says. The business can say, you're an independent contractor. You can sign a document that says, I'm an independent contractor. But what matters is what a judge or a jury says when they look at how the work is carried out and how much control an employer has. It's a legal determination that is not determined by either an employer or by an employee himself. But this control test, saying, well, the more control you have, the more control an employer has, the more likely you have an employee worker, has two big problems. And these problems are not new. One problem is that it is a subjective test. So judges have looked at the same exact set of facts and come down very differently as to whether someone is an independent contractor or an employee. One of the best examples of this is with FedEx home delivery in the US. So you have one decision where the DC Circuit, a federal circuit, decided that for the purposes of unionization, FedEx home delivery drivers are independent contractors. They cannot unionize. And then you have the Ninth Circuit, another federal circuit in the US, who looked at the exact same set of facts and said, no, these drivers are employees for the purposes of state employment laws, that they should get the minimum wage, that they should get overtime protections, they should get vehicle reimbursements, etc. So that's one big problem. The other problem with the control test is that it's very difficult to enforce. So businesses, particularly those with deep pockets, look at a decision that says, look, you control your workers in this way. They'll say, look, you control your workers in this way, and therefore you have employees. And then the company says, okay, then we won't control our workers like that anymore. And so I've written about this quite extensively, but a really good example is, again, this Alexander v. FedEx case in which the judge said FedEx drivers are employees, and FedEx just used the decision to rewrite their contract. And in the end, the plaintiffs in the case actually ended up worse off than they were before. So FedEx completely evaded the law and continued to treat their drivers like independent contractors. So in recent years, as you all are aware, contract work, independent contracting, has grown both through on-demand platforms and through crowdsourcing labor platforms. both of which rely on putative independent contractor labor. Now, note that there is nothing about a digital platform, about having an app on your phone that you use to work, that necessitates that you are an independent contractor. The fact that it happens via the internet and the fact that it happens digitally has little to no bearing over the whether or not the companies choose to treat workers like employees or independent contractors. But again, it's much cheaper to choose to treat workers like independent contractors. So that is the direction that these companies have gone. They've used the internet to amplify, to extend this kind of very precarious, unprotected, unregulated work. So while the number of app-based workers, Uber, Lyft, Instacart, DoorDash, Postmates, Handy, well, the number of these workers who work on these platforms or through these platforms remains comparatively small to the larger labor market in the US, the potential for this sector to grow and for industries to reproduce this model across the service economy looms quite large. The potential for labor platforms relying on non-employee labor to exacerbate poverty looms quite large in the debates about the future of work and of workers in the US. So I have gone to any number of conferences over the last 5 years, and this is the central question. When you're thinking about the future of work, is this what has happened to the taxi industry with Uber going to happen to every service economy, and how can we stop this, or every sector of the service economy? Let me give you some background on these companies. So Uber and Lyft first appeared on the streets of San Francisco in the shadows of the Great Recession. The first people who told me about them were taxi drivers who called them bandit tech cabs. They operated under the guise of sharing and trust building and launched to a captive audience. In a period of heightened unemployment right after the Great Recession and distrust in government on both the left and the right of the political spectrum, the companies capitalized on the public appetite for easily accessible jobs and economic remaking to introduce these business models built on unregulated labor. Uber and Lyft and another company that's now out of business, Sidecar, argued that their technology platforms didn't produce work, they produced community. And their public relations message was that they did not employ people, but that they empowered them. So belying this seductive narrative, of course, are anti-competitive business practices and insecure work. So the labor platforms, particularly Uber and Lyft, but this is true also of Instacart, Postmates, all of the big American labor platforms, they do not facilitate free markets or the free flow of information. These companies set fares. They control worker behavior through algorithms, and there's been a number of exposés on this particular issue. And they unilaterally and sometimes inexplicably terminate workers. They also collect a great deal of data on drivers and consumers. That data becomes proprietary and is used not only to sell to third parties, but also to personalize prices and wages. So in this sense, the prices are not based on supply and demand, but on how much you can and will pay. In many cases, both prices become predatory and wages become predatory. So drivers will show you that the fare that they get is not dependent on who's closest to them, but on sometimes how much battery they have left on their phone, on the pattern of their day and what Uber knows about the pattern of their day. Similarly, the price that you might get for your Uber might differ from the person sitting next to you, even if that person is going in the exact same place, because your prices, again, are personalized. They are not based on necessarily based on demand alone or supply alone. The companies, meanwhile, claim to facilitate micro entrepreneurship. In realities, workers bear all the traditional risks of business. So in the Uber and Lyft context, these workers provide their own car, their own phone, their own hybrid car insurance, gas, but they have very little to no control over the business itself. So unlike small business people, they cannot negotiate prices, the terms of their work, or even develop their own clientele, which is quite common in the taxi industry.
Veena, you have about 5 minutes.
Okay. And although the companies tout flexibility, the time schedules of workers are highly incentivized by price structures. So in order to make money, drivers have to work during particular hours. Full-time drivers frequently work more than 60 hours a week, even in busy metropolitan areas, and their hourly incomes fall well below the minimum wage. So most legal scholars will tell you, in the labor and employment law world, will tell you that these folks are actually legally employees, but it's been very difficult to enforce a change in how these companies operate, to force them to treat their workers like employees, because they've curtailed class actions through arbitration agreements. And until recently, there's been a general lack of political will. So the question, I guess, is what happened in California to change this? We got a Supreme Court decision in which I was actually cited that changed from the control test that I referred to at the first part of my talk to the ABC test. So it is no longer how much an employer controls you that decides whether you're an employee. Now there is a presumption of employee status. And if an employer wants to use an independent contractor worker, they have to prove three things, all three things. They have to prove that they don't control the worker. They have to prove that the work takes place outside the usual course of their business. And they have to prove that the work that the person is doing happens outside of or is part of a customarily established independent trade. So the key prong is the B prong, that the work takes place outside the usual course of their business. And the example the court gave is that if you are a retail establishment and you hire a retail worker, that retail worker is doing what you, the retail establishment, do. They're selling clothes. But if you hire a plumber, that plumber is doing something very different. And so it is likely that that plumber in that context is an independent contractor. So as you can imagine, this scared all the gig companies, because what is Uber if not a taxi dispatch service? And we thought that because they've been so successful in getting laws that they want to see passed, we thought that they were going to essentially override this decision and get a law passed on the state level to say that they were exempt from this law. But instead, the California state legislature, which up until now has been very, very obsequious to these tech companies, decided that they would codify the law. So now on January 1st in California, it very much appears that gig workers will or should be treated like employees. Unfortunately, nothing magical will happen, because the companies maintain that the law doesn't apply to them, and that they need a carve out themselves just in case it does apply to them. So they are using our popular referendum process. They've pulled together $150 million to fight this law. And meanwhile, drivers groups, unions, and state actors are working together to ensure robust enforcement. And in fact, the reason I can't be with you today is because I have spent the last few days at a conference talking about how we are going to force these companies to treat their workers like employees. Professor Park had a number of questions for me that I was hoping to get to. I'm happy to get to them in the Q&A, but let me just quickly say that the sad part of this is that taxis are going to be impacted negatively. So taxi companies are barely surviving in San Francisco. Although the drivers make around the same amount of money as the Uber and Lyft drivers make, the companies themselves don't have the venture capital funding that Uber and Lyft have. Notably, Uber and Lyft have never made money, and in fact, the taxi industry, in its unregulated form, has shown itself to be a highly unsustainable business model. But the taxi companies don't have venture capital funding, and so if they are forced to treat their workers like employees, they will likely go out of business. Not because they can't pay minimum wage and workers' compensation, but because lawsuits will force them to pay back wages and damages, and their companies just can't withstand that kind of remedy. That said, there is a lot of potential here to bring up the standard of labor in this particular economy. And so, in California, I think drivers groups and unions and workers are actually quite hopeful.
Okay, thank you. I don't know whether you can hear it. We are giving you applause. Yeah.
Thank you. I can hear.
Okay.